Hello, welcome to this data protection presentation for the Scottish Law Agent Society. I'm Andrew MacQueen and I'm the Global Group Data Protection Officer at John Menzies plc, and I'm also Associate Lecturer at the Robert Gordon University in Aberdeen. Today I'm going to be talking about protecting personal data under the UK Data Protection Act 2018 and the EU General Data Protection Regulation, or GDPR. Why am I looking at General Data Protection Regulation, you might be asking, given the fact that we have now left the European Union? Well, the UK Data Protection Act and EU GDPR came into force both on the same day, the 25th of May of 2018, and the UK Data Protection Act almost identically mirrors the articles that are drafted within the regulation in the subsequent sections of the domestic law. The principles, the concepts, the framework is pretty much identical. There are some variations within the UK Data Protection Act. For example, things covering the likes of processing personal data for the purposes of detecting or preventing crime. One should familiarise themselves with both laws. The GDPR is still applicable because of its global territorial scope as per Article 3 of the law. So for the purposes of this presentation, I will primarily focus on GDPR and caveat the UK Data Protection Act where applicable, or draw comparisons as necessary. So why was the GDPR required? Why didn't we just stick with what we had? So the history of data protection is quite long, and indeed the sort of term of data protection sort of came into fruition in the sort of early part of the 20th century. Data protection can loosely trace its roots back to the concept of privacy, and privacy being sort of a coined term that was focused on academically by Samuel Warren and Louis Brandeis in their work Right to Privacy in 1890. And if one was to look at some of the judgments that have been passed in some historic and indeed important cases with regards to data protection, to name but a few, TLT versus Secretary of State, the Vidal Hall versus Google, and more recently, and one that we're still waiting to hear more on, Lloyd versus Google. The data protection almost acts as the catalyst to questions of privacy. But for the purposes of today, I'm not going to concentrate on that in any great detail, but it's worthwhile having some level of awareness that data protection and privacy are very, very separate. You will hear them being interchangeably used. I don't personally condone it. They are both very separate rights and noted so within the Charter of Fundamental Freedoms. But ultimately, the rationale and the purpose of GDPR was to bring some level of consistency around data protection laws across Europe. To give an example, the likes of France have always been pretty conservative with a small c when it comes to the rights and freedoms of individuals, and their laws on data protection were pretty robust, particularly around the likes of processing biometric information. So the idea was to bring this into play. And if one was to think about how technology has advanced, I mean, the first iPhone came into being, I think it was around about 2009. You know, fast forward 12 years and look where we are. You know, we're talking about folding phones and folding screens, and our ability to send vast quantities of data in a very short space of time has fast excelled itself in a very short space of time. So the law needed to change to obviously think about those changes. At its core, the GDPR looks to not just standardise data protection law in the member states, but to strengthen the rights of individuals and ensuring a level of accountability of demonstrating particular principles for processing data by organisations. It's achieved by the regulatory oversight of the supervisory authorities. In the United Kingdom's case, this is the UK Information Commissioner's Office, which has a range of powers to restrict, to audit, to review, and to fine organisations that are not complying with the data protection law. The law obviously has the regulatory fines aspect of it, which are not to be sniffed at. If one looks back last year at the likes of British Airways, the fine that was imposed on them was almost eye-watering at first. It was 183.39 million. This was reduced later to 20 million in a reflection to the COVID-19 impact on the aviation sector. But Marriott Hotel, another example, which was fined 99.2 million for a breach that happened there. So these are eye-watering sums of money. Other things to think about is individuals can raise their own proceedings against organisations under Article 82 of the GDPR or Section 168 of the Data Protection Act, which gives them the rights to judicial remedy for a data for lack of data protection. You may also find that entering into contracts, more and more now, you will see data protection agreements or addendums. Failure to comply with those may result in a breach of contract and could see some level of liability or indemnification requirements. And there's also reputational damage implications as well that one needs to consider. So those are a whole host of things of how compliance with data protection is achieved. And the key requirements is effectively to ensure that your staff are trained and are aware of the obligations under data protection. And not just trained, I would advocate that one should also be thinking about continuous engagement. For example, keeping people up to date of key changes, and also thinking about what they need to do in terms of complying with internal policies, procedures, and who's going to manage data protection compliance within the firm. Who's responsible for that? Whilst you may not require a data protection officer from a lawful perspective, you do still need someone to have some level of oversight to manage data protection compliance. So why do we need data protection? What is its purpose? Well, I mean, data protection is effectively protecting any information relating to an identified or identifiable living person. And this includes their personal data, which could be their name, their date of birth, all the way to their political opinion, their health information and biometric information. We are now living in a more globalized world than ever, and I think it's it's important to highlight that the recent events of COVID have demonstrated our dependence on technology and our use of technology. And as I previously noted, one can send vast quantities of information in a very short space of time. To that end, obviously, the data protection framework was created to strengthen the rights of individuals who may fall foul to the negligence or the disregard of protecting personal data by some organisations. And that's obviously, as I've mentioned, remediated by the likes of judicial remedy, contractual remedy and regulatory remedy from the supervisory authority. But it is important to think about how the world is changing. Data protection law globally is changing. For example, in Canada, there's changes to data protection law there in the new law that should come out into play next year or the year after, which will be called the Canada Privacy Protection Act, which levies fines of up to 5% of global annual turnover. And if one goes over to Singapore and looks at the PDPA, you'll see fines that can be imposed of up to 10% of global annual turnover. So there's definitely a step change from a regulatory perspective, and I would say that that's definitely in line with the way in which people or organisations are processing data, but also the expectations of individuals. So what is personal data? Personal data is given an incredibly broad scope, and in short, personal data can mean information relating to any living individual. This might be a client, it could be an employee, it could be another partner, it could be a public official, it could be a range of individuals. Indeed, the scope is very broad. You will see that things that might constitute or you can perhaps relate to is likes of identification documents such as passports, as part of your AML requirements as a lawyer, or drafting of wills, precognitions, case notes, doing creditworthiness checks, credit card information, just the name and contact information of your client, or indeed of your employee. So the personal data is everything that makes you the person that you are, in short, whether it be your eye colour, your hair colour, and indeed Elizabeth Denham has been known to have said that she couldn't really envisage anything that wouldn't amount to personal data relating to a living individual. So it's a very broad scope. So personal data is everything that makes you the person that you are. Special category data is those items and attributes of data that are slightly sensitive with regards to who you are and makes you slightly different to another Andrew MacQueen or Jane Smith, for example. Under the GDPR and the UK Data Protection Act, there is a general sort of prohibition against processing of special category data just because the sensitivity of it and the sort of higher risks of the sort of potential harms that could come around if that information was to be breached in some way. In short, you can categorize each of the bullet points which are special category into four sort of buckets, which is race, belief, body, and sex. As highlighted, as much as is prohibited in many respects to be able to process this data, if one is able to demonstrate a compelling reason, which I will come on to in slide 10, you are able to process that data, but we'll come on to that momentarily. So I've mentioned data processing a lot, and you're probably sat there thinking, what is processing? Processing, like personal data, has a very, very broad scope, surprise, surprise, and basically it relates to all of the activities from the point of collecting personal data right up to its destruction. So, attached to the slide are some examples of processing personal data, and one would highly recommend, whilst it might not be a legal requirement, to ensure that there's a document relating to your activities and what data might be processed within those activities. This is known as a record of processing activities. It's an Article 30 requirement for some organisations, but it's a great demonstration tool for being able to highlight the data that you're processing, the purposes of processing, the the retention and duration of processing, and what that activity entails. It might actually be an activity that has a slightly more sensitivity around it than normal. So it's definitely worth having a look at that. It is if it's something that you have the time to do, but it is really important. There are some organisations and some of yourselves that are probably watching this that might actually be captured as part of the Article 30 requirements under GDPR. So, GDPR stakeholders. What does this all mean? Well, I've covered what personal data is. I've covered what processing is. But there are other terms and phrases that you will come across as part of your engagement with data protection. I mentioned earlier that a data subject is a living individual to which you're processing the personal data. So it's a legal term that's noted within the regulation and the Act. Other terms that you will come across is controller. So a data controller is ultimately responsible for the processing of personal data. They determine the means of processing, decide how to collect it, how to use it, and this can be anything from a large multi-scale organisation right down to an individual sole trader. If you're an employee acting on behalf of your employer, the employer is a controller. So in every case where there's any of you watching this presentation and trying to get to terms with what a controller is, if you employ individuals, you're automatically a controller because you're determining the means of how you're going to process that data. That means that the controller is responsible for ensuring that the processing of the data complies with the relevant data protection law. A processor, on the other hand, is a separate organisation tasked with doing something on behalf of the controller. So a good example of this that I often refer to is thinking about if you outsource your HR or outsource your payroll, you will have a contract in place demonstrating what the expectations of that contract. But within there, you will be highlighting, most likely, need to be highlighting the categories of data that are being processed, and what you want them to do with that data, how they treat that data, etc. And also matters regarding disposal of data upon the completion of the contract. It is still the responsibility of the data controller, so if the processor should suffer some level of a data breach, the data controller is still responsible for reporting that breach if applicable. And effectively, the processor is considered to be pretty much the same as a controller from the perspective of if something goes wrong, the activity should have probably been getting conducted by the controller in the first place, and the controller needs to ensure that there's the adequate level of protections in place with anyone that they engage with as a processor. So definitely have a think about some of the third-party suppliers you might rely upon. Those organisations will invariably be a processor, and you may even find that the processor sub-processes some of the operational activities, which should be agreed within the contract that you've signed up to with them. A data protection officer is effectively what I do on a day-to-day basis. The designation, position and tasks of the DPO are stipulated within Articles 37 to 39 of the GDPR, and respectively within the appropriate sections of the Data Protection Act. The data protection officer is not mandatory in every case, and indeed I'm sure there are many of you that are not captured as being in scope for a data protection officer. I would say that sometimes that can be a remiss view, because just because you don't need a data protection officer doesn't mean that you aren't expected to comply with the data protection law. So you may want to consider having somebody responsible for data protection. They just might not have the title of data protection officer. Data protection officers, similar to a solicitor, are bound by independence. You will find that in recital 97 of the GDPR. So, you know, if you were a slightly larger firm, you might think about, oh, well, the marketing manager isn't doing very much at the moment, and giving them the title of DPO as a protected title could be deemed a conflict of interest, given the sort of the objectives of both parties, one more of a as an advisory position, the other more as an actor within the firm. So yeah, the data protection officer is an interesting role. It can be a very lonely role at times, I must confess, but it's a protected role under the regulation. And whilst, as I've highlighted, you may not require a DPO, it would be remiss to consider that, you know, not having someone responsible for data protection within the firm. And finally, a supervisory authority. The supervisory authority in the United Kingdom is the Information Commissioner's Office, and is effectively a fancy term for the regulator responsible for the oversight and monitoring of organisations. The ICO regulates data protection within the UK, and they do offer advice and guidance to promote good practice, monitor breach reports, conduct audits, advisory visits, handle complaints from individuals. So they have quite a wide expanse of a remit in terms of being a regulator. So I highlighted that at the outset that organisations are expected to comply with a range of principles from a data protection perspective. The UK and the EU data protection frameworks are identical. They consist of 6 principles, which then have this overarching principle of accountability. I'm not going to obviously read word for word what's on here, but effectively, to process personal data, you need to be able to demonstrate compliance with each of these 6 principles. I will cover lawfulness in a bit more detail momentarily, but fair and transparent, how do you demonstrate this? Well, you may do this through privacy notices. And within your privacy notice, you would highlight the purpose of processing the data, why you need that data and how you keep it up to date, who you might share that data with and why you would share that data with them, and also aspects of security, how you're going to secure that data. So that's how you would notify an individual of how you're going to process their data in a fair, lawful, transparent manner, whilst adopting and highlighting how you comply with the overarching principles. Obviously, keeping data for longer than is necessary is not an uncommon theme for me to see in my career. Prior to being a DPO at John Menzies, I was a consultant, and the amount of organisations that I've come across that just hold on to data for a rainy day. You know, as lawyers, you'll need to obviously think about why you have that data and what purpose. If there's a valid business justification, or if there's a lawful requirement for you to maintain that data, it might be in line with the statute of limitations. But ultimately, you need to think about why you have that data, why you're holding on to it for so long, and how you're going to dispose of it. But in the time that you've got it in your custody, you need to keep it safe and prevent it from unauthorized attacks. That means obviously ensuring that if it's in a filing cabinet, you think about locking that filing cabinet and who has access to it. If it's on an IT platform, you may need to consider some level of encryption. You might want to look at some form of information security tools. Obviously, there's an element of proportionality around all of this. So it might not be sensible for you to sort of all run out and start looking at buying cybersecurity software to implement against what is maybe a small network, but obviously it wouldn't be a bad idea to maybe consider having conversations with some IT security experts if you haven't already done so, if you're reliant upon technology and how to ensure that data is kept safe. And as I say, if it's paper records, just think about where it's stored, how it's stored, and why it's stored in the facility that it is. Demonstrating accountability. It's a very sort of wishy-washy term, but effectively the sort of principles of processing data has to be from the top down, from the most senior partner to managing director, chief executive, right down to your trainees, your paralegals, to your secretaries. The accountability starts at the top. That's how it works, and demonstrating that could be bestowing some responsibility on departmental owners. So you might have a head of litigation, a head of employment law, a head of contracts, etc. In such cases, you might want to bestow some sense of responsibility. In such cases, I would maybe recommend setting up something like an information governance committee, whereby you can exchange how you're complying with the principles, and that doesn't need to be an ends of the earth type exercise. As promised, I did say that I would look at lawfulness in a bit more detail. So basically, there are 6 lawful bases that exist. I always remember it with CCL, VPL, so consent, contractual obligation, legal obligation, vital interest, public interest, and legitimate interest, or 1 consent, 2 obligations, and 3 interests. To process personal data, you need to rely upon one of the 6 lawful bases. Consent is one that people often seem to jump straight to. I would always err caution. To demonstrate compliance with consent, you need to be able to engage with the individual and have an intelligible response of consent. So basically it needs some level of engagement from the individual. The individual also has to have the right to withdraw their consent. So it might not be a suitable form of lawful basis. And furthermore, as the data controller, if you are processing data on the basis of consent, you're expected to manage and maintain that consent. In other words, you are the one that is responsible for demonstrating how you've obtained consent in a lawful manner. So it's not always the most applicable lawful basis. And I've seen examples of whereby there's almost a sort of Damocles held against above somebody's head, or a carrot and stick effect. And basically, it has to be freely given. You cannot compel somebody to give you consent. For example, you would not rely upon consent for the purposes of processing somebody's information for the purposes of payroll. A contractual obligation is almost self-explanatory. A good example of that would be processing data in line with an employment contract. You will process that in discharging the obligations that are set out in that contract. A legal obligation, again, very similar. You'll maybe have a regulatory obligation to process certain aspects of data or to transfer certain aspects of data. A good example of that might be the likes of the 2-pay regulation, where there are aspects of personal data that need to be transferred to the new employer. Vital interest. The best way to describe vital interest is and I don't think as lawyers you'll really ever come across it, but ultimately if somebody was to be struck down and was unable to communicate or give consent, this would be the default position. And it would usually be a life and death situation. So if a paramedic were to arrive on scene and start to process information that they've already found out about you, they would be doing that in vital interest. Public interest is quite an interesting concept. It is pretty limited in terms of its scope of use and in terms of its definition. It's usually public bodies that would rely upon public interest. A good example of that would be the likes of the NHS processing data with regards to COVID, and that would be done in line with a public interest or a public task. But a large organisation couldn't necessarily rely upon the same, because the organisation doesn't have the same obligations as the NHS. And finally, legitimate interest is one of the probably almost go-to lawful basis for some organisations. I think it would be remiss to rely upon legitimate interest in every case. You need to do a legitimate interest assessment, which you can find upon the ICO's website, which effectively it requires you to do a bit of a balancing act. With legitimate interest, what you're effectively saying is that you've considered the rights and freedoms of that individual, that data subject, and considered it against the interests of the company in terms of what they're wanting to process and why they want to process it, and deemed that the processing by the company outweighs the rights and freedoms of an employee or an individual. Prime example of that is the COVID testing that some organisations are conducting at the moment in-house. It would be in the legitimate interest of the organisation to do so, because what they're effectively doing is trying to support their obligations of health and safety. Obviously that's health related data, and you'll probably note from the previous slides that that is prohibited. But there are ways around that. So the ways around that include valid exceptions for special category data. So effectively this is what you would rely upon if you want to process special category data. Explicit consent is effectively the same as consent, however it has to be without a doubt, or beyond the bounds of reason that the person has consented to that particular activity. In terms of obligations, that would be the most appropriate valid exception if you're using legitimate interest for processing COVID assessments of employees, because what you're doing is you're balancing that against your obligations under health and safety law. Again, vital interests is in there. If you're a paramedic, you're going to be processing data that you come across, whether it be from somebody's wallet or managing to try and find details of that individual, which may include their health data, and obviously that's in their vital interest. One I've always found quite interesting is not-for-profit organisations, but part of that comes down to some foundations and not-for-profit organisations need some levels of special category data to support funding, or to be able to note where funding has come from. For example, if it's a political somebody with a major political affiliation. If it's been manifestly made public by the individual, so if I turn around and say that I suffer from dyslexia, and I'm quite open about it, and I published it maybe on social media, or I've discussed it in in a news article, the argument is that the special category data and the special category status is then diminished as a result. You can process special category data on the purposes of establishing, exercising or defending legal claims Prime example of that might be the likes of a personal injury claim. Reasons relating to public health or in the public interest in regards to public health, again, think of the NHS and their COVID testing at the moment, or archiving purposes in the public interest. So, the National Records for Scotland is a good example, and they do have some aspects of special category data that's processed and within some of their records. But it's worthwhile remembering, if you are processing special category data, you first need to rely upon a lawful basis under Article 6, and then a valid exception under Article 9. So it's a two-step process, you would need both. Security of personal data is probably one of the most contentious and indeed one of the most important aspects of processing data. Many of the notable data breaches that you'll have become aware of are related to digital related information, or information is stored within an IT format, and is a result of a particular type of cyber attack, whether it be a hack or whether it be with some form of ransomware. To that end, obviously appropriate security is a very broad term and a very subjective term, and that is very much intentional. And the reason for that is because a one-size-fits-all approach is not applicable. Each of you will need to consider what security means in your own organisation, because firstly you'll need to determine what format the information is in, whether it be digital or paper format, and you will then need to consider what's appropriate in terms of the security around that. But to try and give some flavour of the things that you need to think about in security, there are 4 things to think about. One is the access. Who has access to the data and why? Where is the data stored? How is the data transferred? And then how is the data disposed? Thinking of access, whether it be digital format, you would be thinking, if it's on a computer, that you would want to have some level of password protection there, and make sure things are password protected. I'm a huge advocate for people who want to password protect Word documents and Excel spreadsheets and the likes, especially if they have any intention of transferring them on. But having them password protected on top of your current layer of protection is not a bad idea, and I certainly would advocate it for some of you that are perhaps dealing with things that are maybe a little more sensitive. Keep your desk clean. I think for some lawyers that's maybe easier said than done. I would certainly say that I do try and practice what I preach, but very quickly can find that paper ends up all over the place. But if you are going to go away from your desk, make sure there's nothing visible, particularly if it's sensitive or relating to a client. Lock your screen when you walk away. If you're going to make a coffee or have a rest break, make sure that you're locking your screen, and you can do that quite simply by holding the Windows key and pushing L. So there's a nice quick way of doing it. And just be aware of your surroundings. I know that many lawyers are usually pretty good at thinking about going into a room if they need to go into an office, going into a room whenever they have a phone call, or indeed if you're sitting with a client and gathering some information, you might not want to have that out in open surroundings. In terms of storage, it's a good idea to ensure that paper records are stored within a filing system and a secure filing system. You may want to also think about in a very unfortunate situation, what would happen if there was to be a fire in the office? Is the storage facility fireproof? That's not necessary in every case. One of the big things I would highlight here is implement a retention schedule, thinking about what data you have or what records you have, and how long you're going to hold on to them for, and what the processes look like around that for disposal, which is obviously something further down the line. And please don't store work-related information on your personal devices. I know that it's sometimes easy to do it, and it means that you can look at things outside of work. If that goes wrong, that can be particularly damaging to both yourself and to your client. So just be extremely cautious if you are transferring data or storing data on personal devices. When transferring, Microsoft Outlook has a tendency to automatically or autofill the to and the CC and the BCC. Be extra vigilant. As a DPO, I must confess that the vast majority of data breaches I handle are related exactly to that. It's been sent to the wrong person because we've relied upon autofill. If there's something particularly sensitive, do not put that into the body of the email. If you're sending an email, what you should do there is either a Word or a PDF, password protect it, and attach it rather than have it in the body of the email, just in case the email goes to the wrong place. When it comes to sending letters and so forth, be mindful of when you need to mark it up as private and confidential. And disposal, ensure that there's facilities available. It might be shredders, it might be confidential waste bins, and ensuring that somebody comes to collect that. And if you are thinking of electronic deletion, then you should think about the procedures of what deletion looks like and what you're deleting and why you're deleting it. So in terms of security, it's very broad. One size doesn't fit all, and obviously I'm not going to preach to any of you in terms of what you should and shouldn't do, but hopefully this gives you a bit of a flavour of some of the things that you should consider and the sort of process that you need to look at. So access, storage, transfer and disposal. Data subjects have got 8 rights in total. Some of these you'll probably never come across in your practice. Certainly I've never come across some of them in my day-to-day job, but for all intents and purposes you should have an awareness of each of them. The first one is obviously the right to be informed, and I touched upon this when I looked at the purpose, the principles of data protection and what you should do in terms of fair and transparent. The right to be informed is highlighting to individuals what data you're collecting on them and for what purposes and whom that data might be shared with. And this is often found in what's known as a privacy notice. I still don't know why we call them privacy notices. As far as I'm concerned, it should be a data protection information notice. However, they are called privacy notices and they're quite often referred to as that. And some are a lot better than others, but there is usually a style to follow. There are some classic examples out there. Look at the likes of the Information Commissioner Office in terms of what content's in theirs if you're needing some inspiration. But it doesn't have to be the ends of the earth stuff, but you do need to have one available to your clients and to your employees. The right of access is a commonly used right. I'm sure any employment solicitors who is referring to this presentation will be familiar with right of access, but the right of access is effectively giving individuals the opportunity to obtain a copy of the data in which you hold on them, and that's you know, that could be very vast in terms of what you could be looking for. It can include emails, it can include likes of text messages and WhatsApp messages. It can include, you know, board minutes and notes that refer to you. It can include, you know, a whole series and a whole host of things. Sometimes one of the things I have to note here is that when it comes to retaining records, less is more. And when you're handling a right of access request, you know, the more you have to review, the more you have to think about your redaction in terms of, you know, company sensitive information or legally sensitive information, or indeed information relating to a third party. It is commonly exercised. People often exercise it if they are disgruntled, or if they have a concern around the processing that's taking place at the said location. So it's worth being mindful of. You may have handled some, you may not have handled some, but be aware that obviously your clients and your employees have the right to be able to access information relating to them. The right of rectification, this is obviously ensuring that information is kept you know, up to date and is accurate and isn't you know, is in a complete state. Universities are usually very good at doing this, obviously, because they have an annual matriculation process for students to obviously update their address, their contact information, etc. When it comes to employees, I'm not saying that everyone's going to be changing address every year, but you should have a process in place to ensure that records are kept up to date. And if it's relating to a client, you know, ensuring that your secretary or your receptionist is ensuring that the details are up to date. It's good practice, and it ensures that the information that you have is the most up to date. I have had a couple of rights of erasure, and this is not an absolute right, might I add, but an individual can request that their information is deleted if it's no longer required or for the intended purposes, insofar as there's no lawful requirement for you to maintain it. So if you have a lawful obligation to still process that data, i.e. just holding on to it, which is a process in itself, then obviously be mindful of the fact that you'll need to think of mechanisms for getting rid of that data. But yes, there are certain circumstances where you would need to maintain that. Restriction of processing. This is not something I've seen exercised, and you know, what one can only say long may it continue, because it can be a very arduous thing to do. But basically, to restrict the processing of personal data is where an individual turns around and says that they don't want you doing anything at all with their data, other than storing it. So it might be that they're in dispute with you over an activity, or they may be in dispute with you over your processes and perhaps the sort of lawfulness of processing. So again, it's not something I've seen exercised, but it can be particularly complex if you have a whole host of different systems and different processes, etc. And that's why having a record of processing activity, whilst it might not be mandatory from an Article 30 perspective for you, but actually having that and understanding your activities is not necessarily a bad idea. Right to data portability, again, not something I've seen acted upon, but basically this has to is an individual's right to be able to obtain information and reuse it for other purposes and transfer to other organisations. Good example of that might actually be a transfer of a pension, or a switcher of a bank account. The right to object is basically the withdrawal of consent, but for the purposes of legitimate interest. In certain cases of legitimate interest, an individual can object. And a good example of that would be where, you know, you might have purchased something, so the organisation then turns around and says as a legitimate interest to market to you. You can object to that marketing and have that stopped. And anything relating to automated decision making, an individual has the right to be able to challenge a process that has no human intervention, and indeed that might be the decision making related to that. Good example of that might be, and I've not seen it in action yet, but I will endeavour to look into it, but a good example of that would be the likes of automated decision making around recruitment processes. You know, it might be that somebody's put down, you know, it's a minimum of a 2-1 entry and they've put 2:I instead of 2:1, or they've written out the words 2:1. You know, if the technology doesn't note how to work with that, it might automatically make a decision to set somebody out of a process. And in such cases, you have the right to be able to intervene and have the decision reviewed. So the data subject rights, they're pretty expansive. One other note to make there is in certain situations where it's the right of access, right of rectification, and right of erasure, you have you're not able to charge a fee for those, and in any case, you know, you need to comply with and ensure that you engage with the individual within a period of 1 month, making them aware that you've received the request. In these cases, you have 30 days to be able to, sorry, I apologise, you have 1 calendar month to be able to process the requests of the individual, and in some circumstances you can extend that by a further 2 months, but you need to engage with the individual and make them aware of why that is. It needs to be a legitimate reason. It can't just be because Joe Bloggs is off on holiday. So you need to think about that as well. And yes, it is without a fee, but in some circumstances where the requests become vexatious or they are becoming manifestly unfounded, you can charge a fee. So if the person's maybe coming back every other month looking for the same thing over and over again, and you would need to be able to demonstrate what the cost relates to. So I hope that gives some clarity on the rights of data subjects. So data transfers, as I've highlighted already, transferring data on a global scale and with mass amounts of data, we can be transferred in literally the blink of an eye. It's an amazing sort of change that we've seen, and many of us may be transferring information within the UK, we might be transferring it to the EU, we might even be transferring it to the likes of the United States. The EU and the UK are still considered to be almost one, and the adequacy of the United Kingdom for the purposes of EU transfers into the UK is still applicable until the end of July, until such times we're still waiting to see whether or not there's going to be an adequacy ruling, which I'll come on to in a moment. And for the purposes of the United Kingdom, transfers to the EU are deemed to be lawful. So you would just need to have a simple contract in place. There's no requirements for special measures. From the context of the EU, transferring data to a country out with one of the member states can be done on sort of 3 different platforms. One would be where the country has adequacy status, and a couple of examples include the likes of Canada, Andorra, New Zealand, and it's likely, but not yet agreed, that the United Kingdom will end up on that list too. The other way is to rely upon agreements. The most common one that I come across is standard contractual clauses, and that is basically the model clauses which are drafted up by the European Commission. You cannot change these, but you can add a data protection agreement which sets out all of the sort of parameters around liability, the expectations of processing, etc., with the clauses as an addendum or an annex, if you will, and effectively the model clauses are there and designed to ensure the transferor to the transferee is doing that in a lawful and safe fashion. There's also mention here of binding corporate rules, and there's only a very, very small number of organisations that have adopted binding corporate rules, but these are usually for massive global organisations with multiple entities. One example would be the likes of JP Morgan's. I know that they have them, but they are particularly difficult to get approved by the supervisory authority. But in any case, the United Kingdom, the vast majority of organisations will rely upon standard contractual clauses because they're far more adjustable, whereas a binding corporate rule, any sort of major change requires a whole new approval process. And approved codes of conduct and certifications, these can be relied on. We did have Privacy Shield with the likes of the United States until the Schrems case had managed to strike that out. But ultimately, the certifications can play a part, but other than the Privacy Shield one, which we'll need to go back to the drawing board, there aren't very many there. Personal data breaches. So when it does go wrong, and unfortunately it's not a matter of if a data breach is going to happen, it's when. How are you going to handle that? And it's important to think about your policies and procedures internally. Who's going to take responsibility for doing the assessment and evaluation and determining whether or not the breach is reportable? Who within the firm is going to engage with the relevant stakeholders to find out what happened and how that's going to be remediated? That's not essential in every case, but you will want to start thinking about that in terms of how you're going to manage a breach situation. Unfortunately, this is something that does happen on a day-to-day basis, and you need to be aware of how how you're going to handle that situation. In certain circumstances, you will have a legal duty to report a personal data breach to the ICO. And this is where it might impact or infringe upon the rights and freedoms of the individual. And in some cases beyond that, where it's a serious risk or a high risk, you will also need to report to the individuals themselves. My view of how you determine a risk and a high risk is whereby it's significant enough that you're having to contemplate the rights and freedoms of the individual. A high risk is where the individual may need to take some direct action, whether it be reporting something to their bank or changing their card details, or having to sort of maintain some level of security over their home. So that's where the differences lie. But effectively, personal data breaches usually act as the catalyst that then leads to the supervisory authority conducting an audit and an investigation in the circumstances of a data breach. A personal data breach is effectively the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. In a nutshell, that is what it is. Obviously, security breaches happen perhaps in some organisations on a daily basis, to not so often, and those vary in terms of severity. I've mentioned that the most common one I come across is where individuals have accidentally sent an email to the wrong person, which is not reportable in many cases, but there are some occasions that it might be. And right up to cyber attacks, which I've not experienced and directly, but I am aware and a part of an industry which has had some level of issues within this field. It's important that you think about how you're going to protect information, and the protection mechanism is really important. one of the things I often say to anybody that wants to understand data protection or the security aspect is, think about putting yourself into the shoes of the person that might be affected. Would you be happy? And if the answer is no, then what are you going to do about it? Now, if it's a massive cyber attack which compromises your bank information, etc., etc., and you turn around and say you're going to be happy with that, then I would say that no reasonably minded person would say that. But it's important to think about what works for you and for your organisation, and that may require engagement with some external consultancy, or looking at at that in a bit more detail internally if you've got the expertise to do so. The one thing that is absolutely essential here, and a sort of leaving point, is you should have a process for identifying, assessing, and where applicable, reporting data breaches. You have a very, very short space of time to report a data breach. So in the case of a breach that merits the requirement to report to the ICO, you have 72 hours from the point of when you are aware of aware of the breach, and you must then report that to the ICO within that 72-hour window of becoming aware. Reporting to individuals is not the same level of threshold if it is a high risk, but it is without undue delay, so you would need to think about that. So again, ensure that there is a process in place, and this is why I'm saying that you may not need a DPO, but somebody should be taking some level of responsibility in your firm for managing the data protection aspects of your day-to-day work. So I've pretty much concluded the presentation here today. I hope it has given you some insight to thoughts and things that you may need to do within your own firms. And I hope it might have given you just a bit of a flavour and an understanding of what data protection is and what it might mean to you, your employees, and your clients. You can find more information at the Law Society of Scotland website. That is one domain which is perhaps applicable, being solicitors. However, there are other platforms, including the likes of the European Data Protection Supervisor, the European Data Protection Board, the Information Commissioner's Office, and the UK Government, to name but a few. I'm also happy to be contacted if necessary, and I'm sure that you can find my contact details accordingly beyond this, if so desired. I hope this has been useful, and I hope it has given you some insight and thoughts. I hope it hasn't confused you too much, but I thank you very much for your attention. I know this is not the most exciting area of law for many. It is for me, but there are sad individuals like me. But I hope you've enjoyed it. I hope it's been insightful and informative, and I'd welcome any feedback that you might have through the appropriate channels too. In the meantime, all the very best and good luck with your data protection compliance programme.